Hey there, Legal Tea listeners. This is your host, Jenny Roselle. This episode of Legal Tea is a cautionary tale. And as a reminder, cautionary tales are real life cases that I've worked on, with real life people, real life facts, though their names are, of course, altered for confidentiality purposes. So today's specific topic is transferring assets, transferring property, say like a house, to a child or children to, quote, protect it from the nursing home. In my brain, I'm saying ruh-roh. Like as Scooby-Doo says, I hear that all the time, and that's a ruh-roh scenario. So in my little estate and elder law world, many tried to attempt this sort of like DIY, do-it-yourself estate planning. And if there's one thing that you don't want to mess up, that you don't want to do wrong, it's this estate planning stuff. Because when someone messes up their estate planning, guess who wins? My profession, the lawyer, Uncle Sam, your state of residency here in Indiana. Those are all people that you don't want to win, do you? But guess who does not win? Your beneficiaries, your kids, your family, and probably your executor's sanity, because goodness sakes, they're having to play cleanup and they're probably losing their sanity. So let's talk about a recent example. When this happened, of a client that thought that the planning they were doing made sense. It was a win-win. It was the best for everyone involved. But turns out they were wrong. So let's name this client Beatrice. So old Beatrice, she had a friend who lost everything to a nursing home. So to protect her and her family, Beatrice thought that she should transfer her house to her 3 kiddos. She thought that was a marvelous idea. So she did it. She transferred her house to her 3 children. And when I say, just for clarification, when I say transfer the house, I mean she literally did a deed and moved her house from her name to her 3 children's names. So some time passes, so the deed got done, it got signed, it got recorded, and some time passes, then bam, her magnificent plan went sideways because one of her children passed away. To clarify, Beatrice and her 2 other children were still living, so just one of the children passed away. And you see, property like a house or like land, we call it real property in my little lawyer world, operates differently than most assets. What do I mean by this? So let's chat about that for a second. So think of like a joint bank account. Maybe it's a joint bank account between you and your spouse or you and your child. You get the point. So if one of the joint owners on that account passes away, then account naturally and legally defaults in ownership to the surviving owner. Easy peasy, right? So husband and wife have a joint bank account. Husband passes away. That account defaults in ownership to the wife. That is not how real property like a house or land, that's not how that kind of property works. Instead, property gets transferred totally how the prior deed was written up. And all too many people try to whip up deeds without professional guidance, and they get themselves in trouble because they don't know that there are different types of real property ownership, and those different types play out very uniquely if an owner passes away. So generally speaking, there are 3 types of property ownership for a house, land, etc. So let's run through them super quickly. First, we have joint tenants with rights of survivorship. This means that 2 or more individuals own the property, and if an individual passes, the property stays with the surviving individuals. So say, for example, we have Bob, Tom, and Cliff, and they all own a property as joint tenants with rights of survivorship. Cliff dies. Well, now Bob and Tom just own the property. It doesn't go down through like Cliff's estate plan or Cliff's last will and testament, for example. Second type of ownership is tenants by the entirety. And this operates just like the one I just talked about, the joint tenants with rights of survivorship. But tenants by the entirety is exclusively reserved for married couples. So you can't have tenants by the entirety for like you and your bestie or you and your kid. It is totally reserved for married couples. So say we have Bob and Mary. They're married. Mary dies. The property automatically defaults to Bob. So sometimes on a deed, you'll see this tenants by the entirety be referenced as, quote, husband and wife. And if so, in Indiana at least, it's presumed that it defaults to the tenants by the entirety classification and it would go to the surviving spouse. The last one, tenants in common. This means that every owner on that deed owns a respective interest. So let's go back to Bob, Tom, and Cliff, and they own a property as tenants in common. What tenants in common means is that Bob owns 1/3, Tom owns 1/3, and Cliff owns 1/3. And let's say Cliff dies. His 1/3, it would not go back to Bob and Tom by default. It would be distributed according to his estate plan. Meaning if he left a will, say his will left everything to his spouse, well, now Bob and Tom and Cliff's spouse are about to become owners together. So maybe that's okay, maybe that's awkward, who knows? But the thing to take away here is that these ownerships operate very differently. So the kicker is that if the deed is silent, and a lot of people don't know this, so say they put just the names, I transfer everything to my 3 kids as Beatrice did, and they don't put any of these ownership classifications. If that's the case, it defaults to tenants in common, which is kind of odd, right? Tenants in common is that last one. So say someone pulls the deed off the internet and just puts a property in their name and another person's name and does not put any classification at all. The law presumes it's tenants in common, and they each own their respective interest, and if either one of them pass, it's going to have to go down that decedent's estate plan. So that is exactly what happened to this client, Beatrice. So back to Beatrice we go. So remember, Beatrice transferred her house to her 3 kids. She didn't put any classification as to how she was transferring to them. So now we all know it defaulted to tenants in common. She had no idea this was the case. So one of her children passed away, like I explained. Guess what had to happen? Kind of afraid to explain, but here we go. So, that child, legally speaking, owned it was her son, owned a 1/3 interest in Beatrice's house. So because the child, he passed away, we had to probate. We had to go through the probate court process to get the 1/3 interest back to Beatrice and her 2 living children. That deceased child, the son, was married, had kids, etc. So because his 1/3 interest had to go according to his estate plan, which his estate plan left everything to the spouse, thankfully, his spouse agreed to waive her interest and let it pass back to Beatrice and Beatrice's 2 living children. And please note, the deceased child's spouse, she didn't have to do that. She could have caused a ruckus. However, where the story stinks is that for probating the deceased child's estate for that 1/3 interest, they had to hire an attorney, like me. Well, they did. They did it to get it all straightened out. So when I gathered all these facts, when I was meeting with Beatrice, I was gathering all the facts, and especially when I learned the reason why Beatrice transferred her house to her kids, my heart sank. In case you didn't know, there are ways to protect your house and assets against the nursing home, against long-term care. And you don't have to transfer your assets to your kids or beneficiaries. That may be a conversation and episode for another day, but that's not the only option. But Beatrice didn't know that. So I won't bore you, well, today at least, on all the details on how to accomplish this, to protect your house, protect your assets without transferring to your kids. But long story short, how it works is it's utilizing a very specific type of trust, which that trust allows you to, one, gain protection against long-term care nursing home, and it also allows you to maintain control of your assets. So Beatrice could have done this. She could have gained protection and kept her house. Now that is the win-win she was probably looking for. Not to mention, even if that isn't enough to convince you that Beatrice doing this wasn't the world's greatest idea, let me also share a little bit about why this was a bad move tax-wise too. So had Beatrice waited to transfer her house at her death, whether by trust or just her as, when she passes as an individual, her kids would have gotten what's called a step up in basis in tax world. And what in the world does that mean? Well, let's talk through I always think explaining it using a real life scenario explains the whole step up in basis way easier. So say Beatrice bought her house many years ago for $70,000. And now in 2021, say it's worth $130,000. At Beatrice's passing, the kids would inherit the basis of $130,000 and not have to pay capital gains on the difference between $70,000 and $130,000 when the house got sold. So Beatrice transferred her house prior to death. If she did that, so if you transfer the house prior to death, you do not get the step up in basis. So the kids would not get the basis back at $130,000. So in super short conclusion, it hurt them tax-wise too. Let's just say it that way. So ouch, right? Knock them while they're down. I often think about these types of cases and stories, and I wonder, why did they not seek professional legal advice, right? And sometimes I have to assume that people don't obtain legal advice because the cost. And I hear you. I get it. I don't like spending money either. They're afraid it's going to cost them an arm and a leg, right? Legal services usually aren't free. Though when I think about that, I instantly think of the Beatrice examples, that Beatrice and her family would have come out ahead, financially speaking and sanity speaking, had they gotten advice. So next time you consider doing some do-it-yourself DIY estate planning, maybe instead consider getting an attorney involved. Get a second opinion. Get some advice. It'll not only give you an immense, amount of peace of mind, but it may just save you and your family a buck or two. It would have saved Beatrice's family a buck or two. Anyway, so next week's topic is we're back to a current event, current trend. And these are, something I've seen or run across that I think would be interesting on here. And next week, we're going to be talking about something kind of fun, something unique, and something going on in today's age and related to my little estate and elder law world. And you're going to think I'm a little cuckoo, but we're going to be talking about how the NCAA just released rules now allowing college athletes to make money off their what's called, quote, name, image, and likeness. So what does that even mean? So in my world, that means these young adults, these young athletes are going to start making some money. And often youngins don't consider my little estate planning world. So my heart, my brain, it immediately goes to what happens if a college athlete makes a good chunk of change and something happens to the kid, to the athlete, and they don't have an estate plan. So until next time, Legal Tea listeners, we'll talk soon.